Yes, counsel. Good morning.
Good morning. My name is Dennis Shedd, and I'm representing Spassky Alciquiez. Mr. Alciquiez was convicted of armed burglary with intent to commit an assault and battery with a dangerous weapon on Amanda Poisson, and first-degree felony murder for the killing of the man she was with, Carlos Mejia. Trial counsel failed to raise two issues that were important to a proper determination of whether Mr. Alciquiez was acting with the state of mind necessary for a felony murder, and those errors created a substantial likelihood of a miscarriage of justice. Now, the murder statute states that a felony murder is a killing committed in the commission of a felony, and this court has interpreted that to mean that the killing must occur in connection with the felony and at substantially the same time and place. Now, a killing is connected to a felony if it occurs while the felony is ongoing or immediately afterwards as part of an effort to evade responsibility for the felony, such as to aid and escape or to eliminate witnesses. Now, in this case, counsel failed to recognize that the armed burglary was over before the stabbing took place. Now, the Commonwealth suggested that the definition I've drawn for when a killing is connected to a felony is too narrow. And the Ortiz case and some later ones have framed the issue as whether the killing took place in the course of the felonious enterprise. And the Commonwealth interprets that to mean essentially that the killing and the felony must be part of a continuous sequence of events. And if that was all that was required, it would be enough to show that the killing took place at substantially the same time and place as the felony. The connected with requirement wouldn't add anything to that. And that would permit, in fact, felony murder convictions in cases where there was no really meaningful connection between the felony and the killing, aside from the fact that they happen to take place at the same time and place. For example, you could have a situation where somebody goes in to rob a store. On the way out, they happen to see an enemy coming in. They take the opportunity to shoot him. It's certainly a continuous sequence, but there's no real meaningful connection between those two events. And the Ortiz case, in fact, lays out pretty much the exact definition I've set forth, and the succeeding cases talking about felonious enterprise are consistent with that. In Ortiz, what the court said is it was not necessary for the Commonwealth to show that the homicides occurred while the felony was in progress, as long as they were connected and took place at substantially the same time and place. It would be enough if the homicides occurred as part of the defendant's effort to escape responsibility for the underlying felony. Now, in this case, at the time of the stabbing, Mr. Alciquiez was not trying to escape responsibility for the burglary. The only issue is whether the burglary was still in progress at that time.
Well, I take it he was trying to extract revenge, which is sort of why he broke into the house and beat Ms. Poisson, right?
That's right. That's right.
Trying to extract revenge. That was the whole purpose of the break-in. And the assault on the woman and then the killing of her boyfriend.
That's right. And the point here, Your Honor,
why isn't that part of the same scenario?
It's part of the same sequence of events, but it's not part of the burglary. And the reason for that, and the reason it wasn't raised at trial, is Commonwealth failed to recognize, the defense counsel failed to recognize the principle that a crime requires not just an unlawful act, but an unlawful act committed with the state of mind required for the crime. Now, in this case, Mr. Alciquiez hit Ms. Poisson with a battery charger immediately after he entered the house. He then dropped the battery charger, takes his son outside. At that point, he no longer has the intent required for the burglary, the intent to hit her with a battery charger. The felony is over at that point. It's only after that that he goes back in the house, takes the knife from the kitchen, and stabs Mr. Mejia. Now, that was certainly a criminal act. It's certainly part of the continuous.
What if he'd gone back and stabbed Ms. Poisson?
If he'd gone back and stabbed...
He beat her with a battery, now he went back and stabbed her.
I would take the position that's still part of a separate crime. And the reason is this is specifically charged as armed burglary with intent to assault her with a battery charger. If he is acting with some other intent at that point, then it's no longer a part of that crime. And in this case, at the time of the stabbing, he no longer had the intent to strike her with a battery charger.
But isn't that a question of fact?
Huh?
I mean, just because he struck her with it once doesn't mean he didn't want to strike her again.
Well, he certainly, there's no one has ever suggested he was trying to get at Ms. Poisson again at that point. He'd hit her with a battery charger. He dropped the battery charger, gone out, takes his son outside, Then he comes back and
Isn't she hiding in the closet at this point? Hears him come in and
she
goes
went
and
up to
desperately tries to
Mr.
hide somewhere.
Cristoforo's closet. She was in the closet, that's right. And I think the Christian case is a good example of what I'm talking about here. In the Christian case, the defendant was convicted of first-degree felony murder based on an armed robbery. And he argued that the judge should also have instructed on second-degree felony murder based on larceny, on the theory that he only formed the intent to steal after he shot the victim. This court rejected that claim for two reasons. First, it said the evidence clearly showed that he did have the intent to steal at the time of the shooting. And second, the court said that if he didn't have the intent to steal at the time of the shooting, then there's no causal connection between the larceny and the killing. Well, in this case, Mr. Alsacias did not have the intent required for the burglary, the intent to hit Ms. Poisson with the battery charger at the time of the stabbing. So there is no causal connection between the killing and the burglary. So since there's evidence showing that those two events were not connected, counsel should have moved for a required finding on that basis. And were that to be denied, he should at least have asked the judge to define what it means for a killing to be connected to a felony and argue that point to the jury. Now, the second issue is turning to the provocation issue. In this case, Mr. Alsacias went to the house without intending to commit any crime. He went there hoping to be able to sleep there at 3 a.m. rather than having to drive back to Revere.
Well, I'm not sure I agree with that basic premise. Didn't he call her and attempt to find out if someone was there? And he said, the only reason you wouldn't let me come is if somebody's there. And wasn't his intent to find out if she had a man there?
I don't think that's what happened, Your Honor. He did make a call, and he says, I'd like to sleep over. She says no. And then he says, the only reason you'd say is what you said. He said, the only reason you'd say it is if somebody was there with you.
Right.
She hangs up, he calls back, says the same thing. But his purpose in going there, again, it's to sleep there. It's not to check up on her.
No, it's to find out if there's someone there.
I don't agree with. I just don't agree with that reading.
Right.
I don't think that's not an argument that was even made at trial. I don't believe. I mean, I can see why you might say that, but I don't think that's his purpose in going there. He'd gone there at 3 o'clock in the morning, drops off friends in Lynn after spending the night on the town, and he wanted to sleep there rather than driving back to Revere. He calls her up, and certainly when she says no, then he says, well, this is the only reason you'd say that, and he tries to call again. But his purpose in going there, I think, is to sleep there.
Even though she said no twice?
She said it the first time.
She never said,
she
"Come on
hangs
over."
up. He calls back again.
Right? She never said, come on over.
No, she never said.
So he
"Come
went
on
there, notwithstanding the fact that he knew he wasn't welcome there.
He was already there, but he was parked in the front there.
Well,
That's
do
right, he
you
was parked
recall that at one point he said, this is what I wanted to see, you in my house, my bedroom. That's
after this
That's what
incident
he
happened.
wanted to see.
After she had told him, I'm here with Carlos Mejia, and he's hit her with a battery charger, he goes in and sees him in the bedroom. At that point, he says, yes, that's what he says. But that's after she's told him, I'm here with Carlos Mejia. But I don't believe that that's the reason he went there, was to find out if Amanda Poisson is with somebody. That wasn't his purpose in driving there.
Your argument is that he did not go there with that intent.
Right. He did not go there with that intent, and he only formed that intent after she's told him, I'm here with Carlos Mejia. And that time, he basically flips out.
Didn't she tell him that on the phone that she was with?
No, she didn't.
That
On
they
the
were
phone,
watching
she did not say that on the phone.
When he's
She-
outside,
as
she
a matter
says,
of
I'm
fact,
watching a
She
movie.
denied that anybody was there when
When
he
did she
called
say
on the
that she was
phone.
watching a movie with him?
Huh?
When did she say to the defendant that she was watching a movie with Mejia?
When he came up to the door. She told him no, hangs up. She sees the car outside, and then he had a key, unlocked the door, but there was a chain lock on it as well. She comes down to the door, and he says, can I speak to you? She says, I will if you go out in the car. And he says, just tell me if somebody's here. If somebody's here, I'll go away. And at that point, she tells him, I'm here with Carlos Mejia watching a movie. That's when
That's when he
happens.
breaks in and gets
That's
arrested.
when he breaks in, and that's when it begins. That's right.
So you would suggest that if he had killed her, then provocation would be a relevant issue on first-degree murder.
As to the felony murder theory, right.
Well,
Well,
no, I mean, you wouldn't, well,
it would certainly, provocation would certainly be relevant on the two
first-
theories it was relevant at trial already.
right, and that provocation instruction was given with respect to premeditated murder, and was there an extreme
And extreme
atrocity?
atrocity, right.
So that was given with respect to that.
Right.
Okay.
Right. So, okay, so the judge gave the provocation instruction on the other theories, and because this court had stated in Roderick and 3 later cases that provocation doesn't mitigate felony murder, counsel agreed that it shouldn't be given on that theory. And I think counsel should not have made that concession. And the primary reason for that is that context matters in these decisions, and counsel should have recognized that the context of this case is very different from that of any of the cases where this court said provocation doesn't mitigate felony murder. And there's no reason to believe that the court was thinking of this situation when it made those statements. Now, all but one of those cases present the classic felony murder situation, this sort of situation that gave rise to the doctrine in the first place, which is, I attack you, you resist, I kill you. Well, courts decided that a person's foreseeable resistance to a criminal act isn't the kind of provocation that should mitigate a murder. But that's not this case. This case presents just the opposite sequence. In this case, he had no intent to commit a felony until he learned that she was with Mr. Mejia that night. And that sequence, the provocation giving rise to the felonious intent, is the very sequence that authorizes a provocation instruction in other situations.
Aren't you confusing motive with provocation? I mean, that may have been his motive to commit the underlying felony, but it's something entirely apart from provocation, which doesn't even relate to relate to felony murder.
Well, I mean, the felony murder doctrine certainly arose from the situations where somebody resisted a crime, and the court said, created this doctrine to deal with that situation. Said, this we're going to treat as murder. We're not going to let this be reduced to something less, I think. And, you know, this case presents sort of the flip situation. Now, the Roland case is the one case where the court said provocation doesn't mitigate felony murder, in which what this court characterized as provocation did in fact take place before the intent to commit the felony. I'd just like to make 2 points about the Roland case. First is that the court's discussion of provocation, I believe, is dicta, and it was not made with the benefit of any briefing by the parties in that case. The parties hadn't even discussed provocation in their briefs. And I think that's pretty apparent from the opinion itself, because what happened there is that there was a confrontation in a bar. The defendant leaves. He gathers a mob of people to assist him, and 20 minutes later, that mob attacks the house the victim had gone to. And the Commonwealth was appealing the judge's reduction of the verdict, and the judge hadn't reduced it to voluntary manslaughter as he would have if he'd found provocation. The judge reduced it to second-degree murder, and he gave a number of reasons for that, one of them being that the attack on the house was retaliation for that earlier incident at the bar. And this court then likened that to a provocation claim.
How is this defendant even entitled to a provocation instruction?
He's entitled to a provocation instruction because...
Even as to deliberate premeditation?
Huh?
Even as to deliberate premeditation. How is he entitled to that?
Because he goes there, he goes to the house of this woman. He lived with her for over 5 years. They still have an ongoing relationship. Only 4 days before they'd spent the night together, she tells him she still loves him. They might be able to get back together on a permanent basis. And at that point, at 3 a.m. in the morning, after being in a bar and having a lot to drink and using some drugs, she tells him, I'm with Carlos Mejia. And he flips out.
She doesn't say, I'm having sex with Carlos Mejia. She says, I'm watching television with Carlos Mejia.
Well,
We've never said that kind of a statement constitutes adequate provocation.
Well, I think, given the circumstances of the time this occurred, 3 o'clock at night, she was asleep when he called, and she tried to make him believe she was asleep when he called. That was not a particularly credible statement she was making as far as that goes.
But she did not make a statement to the effect, as the victim in Campbell versus Schnapps made, where she pointed to her crotch and says, you're never getting in here again.
Right,
She
but
never made a sexually provocative statement that would suffice for provocation.
I think it was a statement from which you could draw that same inference, Your Honor, and it certainly, I believe it did qualify as provocation in this case, certainly. You know, given the timing, the sequence of events here, I believe that certainly would give rise to adequate provocation.
He had met the victim like 11 days before at a party in the same house?
He'd been introduced to him 2 weeks before as a friend from school, that's right.
Yeah.
And there's no reason to believe that he thought he was anything other than a friend from school until he arrived there that night and she basically learned he was something different.
Wasn't there
I-
evidence that he was angry that night when he met Mejia the first time?
She testified that he wouldn't speak to her after that, but she also testified that he and Mr. Mejia had a perfectly friendly conversation. He got a beer from Mr. Mejia. There was no sign then, and certainly taking the evidence in the light most favorable to Mr. Alsacias, which has to be done in deciding if this sort of instruction is warranted, I believe there was evidence of provocation. And in any case, the Schnapps and Andrade cases indicate that even if somebody has suspicion for months before of another relationship, that's not enough to foreclose a provocation instruction when a killing occurs once that suspicion is confirmed. The Commonwealth also suggests that Mr. Mejia didn't do anything to provoke Mr. Alsacias because Ms. Poisson was the one who told him that Mr. Mejia was in the house that night. But when there's a discovery of infidelity, it's naturally going to create anger towards both parties involved. And the issue is whether there is a sudden discovery, not how it was discovered.
Now, let me get back to the provocation.
Mm-hmm.
She said to him, I'm watching television with the victim. And he's outside the house at that point. There's a chain lock.
Right.
He then comes in the house, hits her with the battery charger. He goes back outside.
Mm-hmm.
He comes back in the house a second time, takes his child away, and there's all kinds of excited activity going on, takes the child inside the car, puts the child inside his car, and locks the car. Then he comes back into the house again. Where's the sudden transport of passion over the information about learning that his girlfriend was just having sex with another guy?
Well, again, this is part of a continuous...
He's conducting business in the meantime.
Well, this is part of a continuous sequence of events, Your Honor. This thing
But
happens...
that's not sudden transport of passion.
I think it is sudden transport of passion. I think there's similar intervals between the discovery and the killing in the Schnapps case, and certainly the Acevedo and Andrade cases have intervals of as much as 7 hours, and the court held that provocation instructions were warranted. This thing all happens in a matter of minutes.
It happened instantaneously.
Schnapps had bought a gun the day before. He put it in a cabinet. His wife makes the statement to him. He goes to the cabinet, gets the gun he bought the day before, and shoots her. That's the sequence.
And it happened within seconds. And the psychiatrist in that case testified that it was that information that caused him to snap.
Mm-hmm. And the Acevedo and Andrade cases were, I believe, 2 hours and 7 hours between the discovery and the killing. And the court in both those cases held that a provocation instruction was warranted. And in this case, the discovery and the killing happened at the same place within a matter of minutes of each other. I believe a provocation instruction is warranted on those facts. I think I just about discussed everything. I just want to say, should the court agree that that the evidence was insufficient to show the connection between the killing and the burglary, this case should be remanded for a trial in second-degree murder. Otherwise, it should be remanded for first-degree murder. At the very least, I believe the facts of this case, which is a completely unplanned incident triggered by the discovery that the woman he had lived with for over 5 years was with another man, at least warrants a reduction in the verdict to voluntary manslaughter. Thank you.
Thank you, sir.
May it please the Court, Kenneth Steinfeld for the Commonwealth. I'd like to focus in on the line of questioning that Justice Spina asked. This defendant got way more than he was entitled to. The evidence did not provide any basis for him to get any provocation instruction on any theory of first-degree murder, principally because the provocation came solely from Ms. Poisson and not from the victim. There is no case in which a person in the victim's standpoint has been held to have provoked a defendant. He had no idea that they still had a romantic relationship. For all he knew, he was spending the night at his girlfriend's house, and an ex-boyfriend shows up. So I think the law has never extended the doctrine of provocation upon heat of passion to this situation. He may have been able to take out his anger on Ms. Poisson and been entitled to a provocation instruction. He certainly was not as to the man upstairs, whom the defense counsel himself in closing characterized as a decent, innocent man who had nothing to do with the relationship between the defendant and Ms. Poisson. Secondly, there was no infidelity here between the defendant and Ms. Poisson. She was unfaithful to Mr. Mejia when she spent the night with the defendant, not the other way around. So I think that the defendant was not entitled to a provocation instruction at all. Lastly, this court has required that the disclosure be sudden. The Andrade case and some of the older cases have implied that a time of that a passage of time may not preclude the instruction, but the more recent formulations by this court in Mercado and Rodriguez have stressed the sudden discovery of spousal infidelity. We're not even at the question here. These people weren't married. They weren't living together. They had broken up for a much longer period than they ever had before.
Does it matter that they weren't married?
I think it does, because in the Mercado case, the most recent pronouncement, this court characterized the rule as a sudden disclosure of present spousal infidelity. So while there have been cases in which the parties have not been married where the issue has been considered, that has not been the focus of the court's inquiry. In those cases, the court has found that there was insufficient evidence anyway. So
Yes, but don't you think that if it was a spouse-like relationship, that wouldn't have made a huge difference?
I think that this court would probably extend it to that situation, like in the Rodriguez case, where the parties had been together for 22 years and had 4 children. I think that it's a reasonable belief that in this day and age that it would have been extended. But as I said, the most recent pronouncement of this court still talks about the sudden disclosure of present spousal infidelity. So on the books, the word spousal is still there. But I don't think that that's a big issue here because of all these other reasons why the defendant was not entitled to a provocation instruction. As to the first issue, the second issue, if the court has no further questions on that one, as Justice Cordy stated, the whole purpose of the enterprise by the defendant was to extract revenge for the information that he had received. And therefore, when he stabbed the victim to death, he was still engaged in the felonious enterprise that had begun at the door. The crime of armed burglary, the predicate felony, was not, in fact, over. The eighth element of that crime, there are 3 ways to prove it, and one is that the defendant armed himself while inside. Here, the defendant did arm himself while inside with a knife, and he then used that knife to go upstairs to kill the victim. So to say that there was a stop and a whole new crime started over again, I don't think is faithful to the cases, which talk about the killing has to occur in connection with and at substantially the same time and place as. And I think that...
Had armed himself also when inside with the batteries, right?
Yes. He had violated all 3 ways to commit the 8th element of the crime of armed burglary under Section 14. He had crossed the threshold. He'd broken and entered while armed with a battery charger pack. He had committed an assault and battery with a dangerous weapon on a person lawfully therein. And third, he had armed himself with a knife from the kitchen before he went upstairs and stabbed him. So it is not right to say that the crime had been completed, nor does the law, frankly, require that the jury be told that if the crime is completed, then you cannot find felony murder. The law provided then and provides now that the jury instruction is that the homicide must be committed in connection with and at substantially the same time and place as the predicate felony. That's what the jury were told in this case. They got the proper instruction that the law allows.
And the timing of this was all within minutes?
It was incredibly quick. The first phone call from the defendant to the house was at 3:18 a.m. The paramedics arrived at 3:27 a.m., 9 minutes later. And the first police officers who responded to the scene, they got there several minutes before the paramedics. So we're talking at most 5 or 6 minutes. And has been pointed out, during that 5 to 6 minutes, this defendant was engaged in a series of transactions of business. He took his son out of the house so that his son would not witness. He changed car keys. This was all part of one continuous enterprise over a very, very short period of time. This is not an hour. This is not even a half an hour.
Because
This
the
is
911 call was placed on behalf of the Amanda,
right.
who had been beaten. in
Right,
the
but I'm
head.
talking about the phone call from the defendant to the house.
It was 3:18.
Oh, that
That
was the
started
call
it to
from the-
wake, yes, that woke him up. That was at 3:18. And the paramedics testified that they arrived at 3:27. So it was sometime after 3:18 that the confrontation occurred at the door. So this is happening very quickly. This is obviously a part of one continuous transaction. And if the members of the court have no further questions, I'll be happy to rely on my brief for the remaining issues.
Thank you, counsel.
Thank you.